Good morning, everyone. It's a pleasure to have you all here in our second meeting regarding the ICCS topic. We are very delighted to have Professor Nord and the members of the ICCS representation to speak today on continuing on behalf of ICCS. We will today have Ms. Lalissa Frödre speaking from the Central Authority point of view. Ms. Lalissa is a lawyer in Brazil, a member of, as I've said, a civil servant, member of the Central Authority, especially in charge of the Hague Convention, Child Abduction Hague Convention. She has a master's degree in LSC and very experienced in international cooperation issues. She will be now today helping us to learn a bit more of our similitudes and distances. And with no further ado, I'll give the floor to Professor Nord. Thank you again.
Thank you very much. It's a pleasure to be with you again after last week. We had a nice discussion. So today the process is going to be a little bit different because we are lucky enough to have representatives of member states of the ICCS. I will just first of all thank them very much for being with us and just introduce them. We have the pleasure to have Mrs. in the order of my screen, Mrs. Chloé Fallis from Belgium, then Mr. Michel Montigny from Switzerland, Mrs. Margot Bruininx from Belgium also, and Mrs. Chloé Hubbard from Belgium. The idea is to discuss today a complete different question. We will study, I hope you see my screen, we will study together this time the normative instruments of the ICCS. I will try to show you the interest of these instruments, of the different conventions, and then I hope that we will save enough time to have a Q&A session with the representatives of the different member states in order to show you the practical use, the practical side, the daily use of these very important instruments in practice. So we will begin first after that general presentation of last week. We will focus on these instruments, more especially two sides, as I mentioned it in the title. We will first study the question of the circulation of acts and then the question of the circulation of decisions. Two different sides, but with some common points, of course. And the first common point is that they constitute the pillar, one of the pillars of the activity of the organization of the ICCS. As we have mentioned it several times last week, international circulation of acts and of decision is crucial for the ICCS. So let's begin first with the question of circulation of acts. I will deal with that question. Camille Reitzer was supposed to be with us, but unfortunately she has an health problem. She cannot attend to that meeting. She will try to join us as soon as possible, but if unfortunately she doesn't manage to reach us, then I will go on and I will also present you the circulation of the decisions in the framework of the ICCS conventions, of course. The starting point, to summarize maybe in a few words the activities of the ICCS, the general goals of the ICCS. Just one phrase may be used: from the exemption from legalization to the adoption of multilingual forms. It constitutes really the starting point and could say the roadmap of the ICCS for the question of circulation of acts, with always two main goals. I mentioned it already last week, two main goals. The first one is to simplify the procedures for you and me, for individual persons who are faced with international questions. And the second side is to simplify also the work of civil registers. And you have, we have said it just before, persons who are working daily for these questions. So we will have the opportunity during the discussion to check if really these instruments are efficient enough in practice or not. Just a few words, maybe, because I'm not sure that everybody knows what legalization exactly means. It's a process of authenticating or certifying a document. So foreign countries' authorities may recognize it as with full legal effect. It's a requirement in most of the countries. Requirement in the whole world, it's the basic principle for a foreign act to produce its full effect. Translation, it's much easier to understand, of course, in the international contexts. It's a necessary step in most of the situations for the understanding of a foreign document. Very easy to imagine a French act invoked in Brazil. Of course, the Brazilian authorities will have many problems in order to understand the French language. So a translation will very often be needed. Then, these two obstacles in practice, they have some consequences. Of course, for the states concerned, it's a waste of time. Can be considered as a waste of time. Why? Because, of course, you will have a mobilization of a large staff just each time to certify these different documents and to check if everything is fine according to the rules of each state concerned. Then for the individuals, for you and me, when we have to prove something abroad, for these persons concerned, the main problem is translation very often because of the financial consequences. It might have a high cost in practice. And also, legalization is not always easy to obtain. In practice, sometimes it might be a real obstacle because the requirement is legalization, but the question is, how can I get this legalization? So very often we're faced with persons who are sending questions to the ICCS, to the Secretary General, because they don't know at all. They completely ignore the way they can use to obtain such a legalization. They are completely lost for this particular aspect because very few persons will have sufficient legal knowledge to know exactly how to deal with this question. And for translation, again, very often we are faced with persons who cannot pay a real translation. It's a very high cost and they are unable to pay for it. So real obstacles in practice for circulation of international circulation of civil statutes acts. This is why these obstacles have been, since the very beginning of the ICCS, an immediate concern. The first conventions of the ICCS are about legalization and about all the problems of translations. I will try to give you examples. Of course, we cannot have a full study of all the instruments each time, but just giving you some examples of the way it works. First, concerning the problem of legalization. To show you that it's a real concern for a very long time, I can give you the example of the first convention, the first ICCS convention, number 1, then, on the issue of certain extracts from civil statutes records for use abroad. So you see the date, it's a very old convention. And you find in that instrument an Article 5, extracts issued under the conditions laid down in the convention shall have the same evidential value as extracts issued in accordance with the rules of domestic law. That's not a problem. And the second part, they shall be accepted, and this is the key point, without legalization in the territory of each of the contracting states. This is maybe the most important rule of that convention. Abolition of legalization between the contracting states of that convention. So it's no more an obstacle between these different states. Second example, also a very old one, second convention on the issue free of charge and the exemption from legalization of copies of civil statutes required. Second convention of the ICCS. The same principle can be found in Article 4, this time, verbatim copies or extracts from civil statutes records bearing the signature and seal of the issuing authority shall be exempted from legalization, again in the respective territories of the contracting states. Same principle, no legalization anymore between the different contracting states. So very important principle, you see, for more than half of a century. The question has been raised last week, maybe you remember it. Main question in practice, of course, relations with the apostille system. Apostille system coming from the Hague Convention of the 5th October of 1961, abolishing the requirements of legalization for foreign public documents. And you know, it's a very efficient system. It works very well in practice. That's true, but you will need an apostille. The question is then, the solutions of the ICCS convention are much easier in practice. You have no requirement at all. You just have an abolition of the requirement of legalization. Under the rules of the Hague Convention, you still have a requirement, obtaining the apostille. Question then, how can we deal with these two systems? Which one must be used in countries in which the two systems are in force? The solution can be found in Article 3.2 of the Hague Convention itself. Apostille cannot be required when either the laws, regulations, or practice in force in the state where the document is produced, or an agreement between two or more contracting states have abolished or simplified it, or exempt the document itself from legalization. So it means that according to the Hague Convention itself, The ICCS conventions must be applied, even in the states in which the two systems are in force. So the principle, you see, very easy to understand. ICCS system is abolition of legalization. Then the consequence, according to the Hague Convention, is that ICCS conventions prevail over the apostille system. And of course, it will be the best solution for all the different persons concerned, for civil registers and for persons who are invoking the documents abroad, because you have no requirements in the frame of the ICCS conventions. So much more favorable to the different persons concerned. I will just tell you a few words about the most recent instruments. We have mentioned the two first conventions. Now I will try to show you the interest of the instruments which are applicable at the moment. The first instrument that must be mentioned in that frame is the convention number 16, so very famous one. The title is the Convention on the Issue of Multilingual Extracts from Civil Statutes Records. And that convention is also called the Vienna Convention. So the date, you have it under your eyes, 8 September 1976. Great success of that convention because we have now 24 contracting states. 24 contracting states. So we will see that according to Article 8 of that convention number 16, extracts shall be accepted without legalization or equivalent formality in the territory of each of the states bound by this convention. So it's again the same principle. 20 years later, we still find the same principle, and that convention is still in force between the 24 contracting states. So no requirement of legalization or of apostille between these 24 states. It's going to be very easy to use the different extracts on the basis of that convention in all the different contracting states. This is the main rule here, so a freedom of circulation between the 24 states concerned. Modernization of the convention number 16 by another convention, a more recent one, modernization with the convention number 34 this time, convention on the issue of multilingual and coded extracts from civil statutes records and multilingual and coded civil statutes certificates. Convention signed at Strasbourg on the 14th March of 2014 this time. So much recent one, a much more recent convention, but always the same rule. Article 5, such extracts and certificates shall be accepted without legalization or equivalent formality in each of the contracting states. So you see, even if that convention is not yet in force, despite signatures and ratifications by different states, you still have the same rules and the same main principles in the different conventions. So we know that legalization is a very complicated system. This is why the different instruments try to overcome that main problem. The results of these different instruments you don't have hurdles on the international circulation of documents anymore. So it's going to be very easy to use these different tools. We're going to see some examples in a few seconds. And there is also an absence of alternative formalities to legalization. So it's much more liberal than the Hague Convention system, than the apostille system. No requirements anymore concerning a formality for your act. If you want to invoke it abroad in another contracting state, you have just nothing special to do. No legalization, no apostille anymore. Then the second main concern of the Iccs, again, since the very beginning, since the birth of the organization, is the translation. Translation of documents. We know it, we have mentioned it before. It might be a real problem for persons who want to use a civil statutes act abroad. The requirement of translation, it might have a high cost. So it's really a practical obstacle, not a legal one, but in practice, sometimes it is the most complicated aspects. And here we are touching, I could say I will just come back. We are touching the hearts of what makes the originality of the Iccs conventions. Creation of new techniques to overcome, again, the problem of translation. This is really the originality of the Iccs system. How can we understand an act coming from another country easily? How is it possible to deal with that problem without using the classical way of translation that needs to be paid by the persons directly concerned? The problem has been solved in the different conventions by using two different methods. The first one is the method of multilingual forms, and the second one is the system of coding of entries and multilingual glossary of civil statutes terms. Two methods which must be described, and I will try to show you some concrete examples, well, for your better understanding, just to show you how it works exactly. First example, we have mentioned it before, the convention number 16. So remember, in force in 24 contracting states. I will just stop the screen sharing and I will try to show you a concrete example of a multilingual form. Can you see it? Is it fine for you? Great. So it's just an example. So in the annex of the convention number 16, the example of an extract of a birth certificate. So you see it here, everything is in French. You have the date, the place of birth, you have the name, you have the sex, you have the father, you have the mother, etc., etc. Of course, it might be very difficult for you to understand. You might have some problems, some confusions if you don't speak a word of French. This is why you will find here in the models the multilingual aspect. So all the different languages of the contracting states will be mentioned. So all the different topics that we have seen on the first page will be directly translated on the act itself. So you know that, for example, the part number 1 here, you know, even if you don't speak a word of French, you know that it's the country, the issuing country. If you're interested in the number 3, you don't really know what it means. You just have to check number 3 and you will see that it's an extract from birth registration with the number concerned. In the different languages, so you just have to identify your own language and you will easily understand that act. So a very efficient system, and of course, I'm sure you've already seen it. You have all the different mentions of the acts in Portuguese also. So very easy to use for you also in Brazil. You would understand everything if you had such an act under the eyes directly, and if you need to understand it. So multilingual forms, you know, very easy to use in practice. And we have, of course, a feedback. We know that it works very well in practice. We still have some statistics. We know that these documents are really efficient in practice in all the different states. A few words. I will just try to come back. Just for me, a practical concern to find the way to come back on the PPT. Yeah, great. So just a few words about the regime of the convention number 16 concerning these extracts, concerning these multilingual forms. You have different points that must be mentioned. Some crucial issues, again, because very often we have questions about these different points. The first one is Article 1st, at the request of an interested party or when their use necessitates a translation, extracts from civil statutes records concerning births, but also marriages or death, shall be prepared in conformity with forms A, B, and C appended to this convention. It means what? The key words here are shall be prepared. I was born in France, and I know that I will need such a document. I need, you cannot see my slide. I came back. I'll come back. Just. Is it good this time? Can you see my PPT? Yeah, great. Thanks a lot. So the keywords here are shall be prepared. It means that there is an obligation for the authorities of the state concerned. I was born in France. It means that I can always get such an act. I can get my birth certificate, an extract of it from the French authorities, those of my birthplace. It's an obligation for them to deliver such an act. I don't need any justification. I have the right to obtain such an extract, a multilingual one. Of course, models of extracts are in the annex of the convention. It is also very useful because it means that in the different contracting states, all the authorities will know such an act. It will not be a complete discovery each time. Everybody in the contracting states will be familiar with these acts. So very easy to deal with it even abroad in another contracting state. Article 2, extracts shall be prepared on the basis of the original particulars, but also subsequent annotations appearing in the record. It means what? It means that an updated act will always be issued. All the different annotations, since my birth, for example, will be also on the extracts. So very useful, again, if you want to invoke such an act, if you want to prove something abroad. And the last very important rule of Convention 16 is Article 8. Extracts shall bear their date of issue as well as the signature and seal of the issuing authority. They shall have the same value as extracts issued in accordance with the rules of domestic law in force in the state from which they emanate. The extracts issued according to the Iccs system, they have the same force as the domestic ones. This means that, of course, such a rule contributes to the attractiveness of the Iccs documents. You will have no discrimination between a classical one and a conventional one. Both have the same force. But of course, the Iccs one will be much easier to use abroad because it will be a multilingual one. So very easy to understand for the foreign authorities. The second system is the system of coding of entries. I will show you again, at least I will try, the example this time of convention, number 34. I will stop and begin again. I hope so, at least. Convention, this time number 34. Is it fine for you? Yeah. So you see the system is a little bit different here. Again, we are in the annex of the convention, the appendices, and you will find, again, the example of a model form of a birth certificate, an extract of birth certificate. You have, again, all the different mentions, the state concerned, the service concerned. You'll have the date of birth, the place of birth, the name, etc., etc. But you have, this time, different numbers. Different numbers can be found in that act. How can we understand this time? You will have, you see, each time for each number, you will have a concrete translation. Here, you will see exactly what it means. So I will just have to switch, to stop again and to switch just a few seconds. If you don't mind, I will show you. I'm sorry, I'm coming back. I will show you how it works exactly. Yes. Here again, I'm coming back on Zoom and I will share my screen. Yeah. So you see, we have this time a complete different system. You will have a lexic, which will allow you to understand the different entries of that act. Again, in the different languages. So very easy. You see different examples of that lexic. You can find it on our website. You will see you have each time that translation in the different languages. So if you have a problem of understanding concerning the number 331, you will easily find the solution in your own language. So a translation not directly on the act itself, but you will have to use that lexic which is on the website and is, of course, on free access. No problem to use it. So the main question, of course, is why such a change? A multilingual form works very well. So why should we change? Why should we use that coding of entry with different numbers? The explanation is easy to understand. It's due to the success of the convention number 16. It was impossible to add pre-printed translations in other languages in the multilingual models. There were too many languages. Impossible. You don't have enough space on the act itself. And the second crucial point is that there was a necessity to adapt the models to the evolution of family law. Just two examples: same-sex marriage and registered partnerships. Of course, remember the Vienna Convention, the date of that Vienna Convention is 1976. These two questions were not real concerns at that time. So just modernization of the system here. But it works also very well in practice. You will have no problem of understanding of the different acts issued in another contracting state. This is for circulation of acts. Just a few words concerning this time circulation of decisions in the frame of the conventions, the Iccs conventions. Of course, we will just give some concrete examples. It's impossible to study all the different solutions. Some maybe symbolic examples might be used. The first one, the convention number 29, concerning very problematic issue, the recognition of decisions recording a sex reassignment signed at Vienna in 2000. You will find in that convention, you will find a kind of balance concerning that issue. First, a principle in Article 1, final court or administrative decisions recording a person's sex reassignments that have been taken by the competent authorities in a contracting state shall be recognized in the other contracting states if at the time when the application was made, the person concerned was a national of or habitually a resident in the state in which the decision was taken. So you see, again, the main principle is the circulation of the decision. It might be a decision taken by a court or by an administrative authority. The only requirement is the need to prove the proximity with the state in which the decision has been taken. That's all. That's the main principle. But of course, the solutions in the different states are not the same concerning that question. This means that you also have exceptions in Article 2. Exceptions, you will find some very classical one in private international law. The first one is the exception of public policy, without any surprise. So the recognition can be refused if it is contrary to public policy in the contracting state in which the decision is relied on. And the other very famous exception, of course, is the exception of fraud. When the decision has been obtained by fraudulent means, then the recognition might be refused. And then you have a third one, also possibility to refuse the recognition when the physical adaptation of the person concerned has not been carried out and has not been recorded in the decision in question. So you have a material solution here, a material exception, a situation in which the refusal will be possible. And the consequences, you also find a rule concerning these consequences in Article 3. The state which recognizes such a decision shall update on the basis of the decision and according to the arrangements provided for under its domestic law, the birth certificate of the person concerned that has been drawn up in that state and or sometimes transcribed into its civil statutes registers. Obligation concerning here the required states. Obligation of recognition this time. I will just check because there is again a question on. Okay. Second example, the convention number 32 on the recognition of registered partnerships signed at Munich in 2007. Last example here. Again, a very important issue in practice due to the development of these registered partnerships in different states. A convention has been concluded about circulation of these decisions. First, you will find a definition in Article 1. What is a registered partnership? It means a commitment to live together other than a marriage entered into by two persons of the same sex or different sex, giving rise to registration by a public authority. Very general definition. The key point is the necessity of a registration by a public authority. Then, the regime, Article 2, a partnership registered in a state shall be recognized as valid in the contracting states. Again, the same system, freedom of circulation. It must be recognized in all the different contracting states, without, of course, any kind of formality or legalization. And the civil statutes effects of that registered partnership, which are prescribed by the law of the state in which it has been registered and indicated in three articles, 4, 5, 6, they shall be recognized in the contracting states. So you will not only recognize the act, you will also have to recognize the effects of the registered partnership, not only the documents, but also all the consequences of that registered partnership. Exceptions, of course, exceptions mentioned in Article 7. I will not mention all the exceptions, but just maybe the most important, the most symbolic one. Recognition of the partnership is manifestly incompatible with public policy in the state in which it is thought. Again, a kind of balance, principle of freedom of circulation, but with some exceptions. And I think this is very important. In Article 9, you will find, again, a certificate. So it means that you will find a model in annex of the convention with a system of coding entries. A contracting state in which a partnership registered shall issue to each partner a certificate drawn up in accordance with the convention, indicating the registration of that partnership. So again, it's an obligation for the member state in concern, and you will have the possibility to prove the existence abroad of that registered partnership by using such a model form, so the same in all the states concerned. So combination of different systems here, you will have a recognition, the main principle of recognition, but also, again, you will have the use of the system of coding entries. So it's the end of that presentation. I think that unfortunately Camille has not been able to join us. So thank you very much for your attention, and I think that I have saved just half of the session for Q&A with the representatives of the member states. So thank you very much. Of course, remember, you can find many informations on our website, and also you can find some informations on our Twitter account. Thanks a lot.
Thank you, Professor Nord, for your very, very detailed and clear presentation. First of all, before handing the floor to the questions, I would just like to acknowledge the presence here of Professor Guilherme Palau from Spain, Professor Fernanda Machado, and the Hague Conference present with Mrs. Page. If I may, there is a question from one of the participants. Perhaps we could start with him, with Q&As. It's Mr. Leandro Matos. Would you like to formulate your... Well, since he raised his hand but is not being able to formulate his question now, perhaps we could pass to the Q&As. Leandro is here, but would you type down your question? Perhaps that would make it easier for us. Oh, Professor Nord, as soon as I get his question, I'll pass it on. Perhaps we could have the representatives speaking first then.
Do you want to give the floor to the representatives of the member states, maybe if they want to add a few words about the concrete use of these different instruments?
That's it.
I don't know who wants to speak.
Well, if you want, I can go first. So for us, in practice, we are very often, we deal very often with the Convention number 16. And very often we have municipalities that ask us if they can recognize the multilingual form from the convention number 16. And it is true that it's very useful and easier, but sometimes we do lack some information because our private international law requires us to look into the consent of the mother in the cases of filiation. And when with the birth certificate, sometimes it's hard to know whether there was consent. But besides that, globally, it's very easier, and the fact that there is no need for the legalization makes it easier as well. I don't know what my colleagues from the Belgian section think, but
yeah, I think it's very useful. Indeed, the Convention 16 we use a lot, and we also ratified the Convention 34. So it would also be great if it would be in force one day, because of the modernization of the forms for the same-sex marriages and all this kind of things. That would be a great thing too.
I do not know if I can add something. My name is Michel Montini from the Swiss section of the Iccs. We have made the same experiences like our colleagues from Belgium. So we use every day the convention, the ICC convention number 16. I must say that the presentation of Mr. Noor was very complete and very useful, I think, to understand our works. They are very useful in comparison with other agreements for our work in the civil status matters. And even more, I would say, than the Hague Convention about the apostille. So I would say the Swiss section of Switzerland has signed the convention number 34, but not yet ratified it because of internal expertises, but we will do that one day. So we think that the convention number 34 will enter in force in some months or years. So and I would welcome as well the interest of our Brazilian colleagues, because it would be very nice if you could come to join us. Thank you.
Well, Maria Rosa, I don't know if I should come now to the floor, but as Maria Rosa explained, I work at the Central Authority for the Ministry of Justice. We have a department at our ministry that deals only with international legal cooperation. We have it divided in coordinations, and my coordination is the coordination of civil matters, and we also have criminal matters and other forms of cooperation. but Maria Rosa told you that I work with the Child Abduction Convention, but actually nowadays I'm working more with the Child Support Convention. Child abduction is another part of our department because it's a very specific matter. And in our coordination, we work with all kinds of requests regarding civil matters, but mostly family matters. It's about 2/3 of our work today is related to requests for international cooperation in matters such as divorce, custody, child support, and successions. Well, this, of course, involves dealing with civil documents on a daily basis. So we have to check every day birth registers and marriage certificates. And one of the difficulties we often find in our work with child support, especially, is regarding the recognition of paternity. And so we have to sometimes have two different birth certificates in two different jurisdictions, because the father recognized the child in one jurisdiction, but the other jurisdiction has a different birth certificate or different rules. So we have to explain all the concepts and terms in our documents to another jurisdiction. So this is kind of difficult sometimes. And well, the birth certificate is the most important document in this cases, because it proves the rights of the child to receive child support, or it proves who has the right to ask for custody. So this is really important for us. And to be honest, as the Hague Conventions, they do not require legalization of documents. We do not have a lot of problems with legalization, but we do have problems with the translations, because it's very expensive to have the documents translated. And in a lot of cases, our parties here, especially for child support, are very poor people, and they don't have, it's easier to have something in English, but we have the problem with the other language. Sometimes it's very expensive to pay for a translator. So I think this would be very interesting to have different forms translated. And I found it was really important to have this concepts explained, because I know from our practice that it's very difficult to explain some kind of concepts like civil partnership to another jurisdiction, and to explain how does it compare to the other state law. So I think it's really, we did not know about your work before this meeting. So I think it will be very nice to discuss it with my colleagues at the department. So I think this is it. I don't have a lot of experience to share with your conventions, of course, but I found it very interesting.
Thank you, Larissa. I think it's interesting to note that Brazil has entered into the Hague Apostille Convention very, very recently. So we are still struggling with, well, it's been a huge advance. It does facilitate a lot, but we are still learning to operate the system. Well, we had a different approach to the legalization of international civil documents. So we are rearranging our system. If I'm not wrong, it entered into force, I think, in Brazil 2017. Larissa would know, I guess, the date precisely, but it's very, very recent for us.
It was 2016, if I'm not mistaken, because I have to say we are not, the Ministry of Justice is not the central authority for the apostille, but we just don't have the capacity to work with so many documents. So this is now up to the notaries, and the Council of National Justice is the central authority, but we were involved in the negotiation of this convention. So, and we, of course, we deal with the documents that have the apostille. Although, as I said, the Hague Conventions, which I work, do not require this kind of legalization. So,
I think last section, the head of the department from the Attorney General's office mentioned our development in the Apostille Convention. But Professor Nord, I have here a question from Miss Page from the Hague. She has a very interesting question regarding, I'm not sure if you have access, but the question regards fraud. And it says, in the absence of legalization and apostille, which mechanism do you have to ensure that the documents are not fraudulent?
Yeah, thank you very much. Maybe the representatives of the member states might answer much better than me, because they are concretely faced with that question. How do they deal with these questions if there is a problem according to their own meaning about fraud? I don't know if anybody wants to answer. Switzerland or Belgium, maybe?
Try, because we discussed sometimes these matters at our assemblies or in our bureau meetings, because it was something that was a problem for some sections. The meaning is, the general meaning is that anyway, our convention do not oblige any states to recognize a fact that doesn't exist, for example. So, but if I well remembered, we put something special in the last conventions. For example, if you check the convention number 34. We have an article 10, which is very general, and it is objection to an accession, because we had a discussion provoked by one section at those times who had a problem with another state, a non-friend state, I would say, and they had some reservations, and so you could say that you do not have to recognize the acts, the civil status acts of these states. But more generally, we consider that even if a document has been issued by a civil register of another country, you could refuse the recognition. First of all, the first mechanism is to ask from authority to another authority. For example, if we had in Switzerland a doubt about the authenticity of a document that has been issued in Belgium, we could have the following situation. The Swiss competent civil registrar would contact his or her colleague in Belgium directly and ask, is it okay? Did you issue this document? That would be for us, for example, the first question. And could you please check in your register if the extract is correct or not? That would be the first step. And then if there are other verifications to do, it could be possible. but we consider generally that our states are friend states, and generally we do not have these problems. They are very, very rare. And for example, the forms you have, so in the appendix you have the models of our forms, but the states can issue the extracts on security paper, for example. For example, in Switzerland we use du papier sécurisé. It would be with special things like for example money, you know, like banknotes, with the Swiss flag and so on. Yeah, so we have many things like that, and as I well remembered, we sent to the Secretary General many examples of our forms. So if we have a doubt, you could check it, for example. I do not know if this answer could be helpful for you.
I can just show you, maybe I will share my screen again, concerning the convention, which has been mentioned by Mr. Montini, the convention number 34. So you have this mechanism, which has been clearly described in here, Article 5.3, in case of serious doubts as to the authenticity of the content of an extract or certificate issued pursuant to this convention, the authorities of the state where that document is being used may request the issuing authority to effect a verification of its authenticity or its content, or in case of an error, to send to them a new extract or certificate. The exchanges between these authorities shall take place directly. So you have a possibility, even an obligation, to have a direct communication in case of serious doubts. It has been now clearly codified in the new version of the convention. So in the Convention 34, Article 5.3. And we have sometimes questions coming from different member states in case of problems to join the issuing authority. It might happen sometimes, and the General Secretary tries to put them in connection in case of problem. I will stop the share screen. Okay.
Yeah, I think maybe I can add, basically the conventions are basically based on trust between the contracting states. So I think that's the most important key of the conventions. For Belgium, we have since 2019 we have a database with all the civil status records. And we also deliver the multilingual forms directly from the database. And there is like a QR code on every extract. Another authority receives the documents. You can check via the QR code if it's a document delivered by Belgium, in fact, delivered by the database. So that's maybe something like an extra check for security reasons. So.
Well, it's very interesting. I do have one question, just an operational question from the government point of view. Are you representatives of ICCS only, or are you central authorities for other conventions too? I mean, I just wanted to understand if there is a necessity of implementing a new central authority, or you can just, in our case, for instance, in the Brazilian case, would it be would it comply with the ICCS rules and norms and ways of doing this? If we simply were to join the ICCS in our central authority, the Ministry of Justice, for instance.
Okay, I can try to answer this question, this very interesting question. You perhaps will see that every national section has been organized for itself, and every state can organize itself as it is okay for itself. So we are a federal state as Belgium and as Brazil. So we have in our country a system, a federal system, and I personally work for the Federal Office of Civil Status. The Federal Office of Civil Status is a section of the Federal Office of Justice. And as you probably know it, in Brazil, the Federal Office of Justice is competent for many matters, from family law to criminal law or public law. In our department, we are competent for all family matters, but in my small section, we are competent for civil status, and that's much to do because we are just 6 persons for the whole Switzerland, but we have many levels of control, but we are the supervisory authority. So we are in charge of legislation in civil status matters. So, for example, registered partnership or same-sex marriage is in our department. Okay. Now, we have also to do with other international agreements, but we are not in charge with them in Switzerland. We are just in charge with ICCS agreements, and we have then to prepare the, for example, the documents for our government to sign it, or for our parliament to sign or to ratify these instruments. But we do that with our other colleagues. Okay, thank you.
Thank you, Ms. Monti.
In Belgium, it's the same. We also depend on the Minister of Justice. We work in the legislation department for family law, Chloe and I. So, but we don't. We have different representatives depending on the aspect of the family law. I work a lot with civil status records, but for example, I don't know, I don't have an example. Depends. We are like a lot of different people that are representatives. For example, I was also in the the European Union Convention on the free circulation of public documents. I also followed this discussion. So, but now it's the department of Chloe Hubert that is competent for it. So I'll give her the word maybe.
Yes, so I would say it's very much like Mr. Montini said. And and like Margot Brunax said too, and that's pretty much it. We were having a question about Brazilian acts. So I just take the opportunity here to just ask you, since the beginning of the COVID, more or less, we are having like electronics version of the civil status of the civil extracts, and we were wondering if for you it's like the same value as a paper version.
Lalisa would like to answer.
Yes, well, in Brazil, this is something very important for us as well, because we have been working with electronic documents for a while. Our judiciary accepts the electronic documents, and in this international request, they have the same value if they go through the central authorities. So we cannot go to a judge in Brazil with a document without passing through the central authorities in some cases. So you do not have to have it legalized or anything. We just trust the other state that the document is and I think this also answers the question about fraud. We just have this system of trust that the central authority of the other state has checked the documents. So in these cases, we do not have any problems accepting electronic documents. And in Brazil, we have even the judicial decisions. I know many states do not accept them electronically, but we have the certification and everything to check if it's really authentic. And well, with COVID, it was I cannot say good side, because there is no good side, but we have evolved a lot in the use of electronic documents, because we had problems with other states that do not accepting documents electronically, but this changed in the last year, and now we have seen that many states prefers electronic documentation. For us, it's much better because it's more practical, and it's less expensive. We just send, and we have been working, especially in the child support area. We have been working with the Hague Conference to be in the iSupport, which is an electronic system to share documents in this area of child support. So I hope this will be more and more common. And for us in Brazil, we do not have any problem accepting these documents if it comes through the central authority.
Don't you also have a QR code like we do in Belgium?
Sorry, I did not understand.
Do you also have a QR code on the documents?
I don't know if what does it mean?
Like a code,
okay, a certificate, like something. Okay, a code you can check in that. Okay, no, we don't have in all documents, but we have a kind of number sometimes that we can check and enter in the website, and then you can check. Especially for judicial decisions, we have this kind of certification, and we have been trying to explain to other states that this works for us, and we have been having success with some countries, but not with all states, because of internal laws that do not allow for electronic documents.
Okay, thank you.
I would also add, not from the practical point of view, but in theory, even if the documents, the electronic documents or digital documents, if they circulate through our Ministry of Foreign Affairs, I would say we would also accept them. I mean, not considering that not only our central authority, but also the Ministry of International Affairs, Foreign Affairs, sorry, but not by a direct exchange. Then that I would say that our judiciary would raise issues on that. I don't know if Lalisa has some concrete case of direct exchange to.
Yeah, we do not know, because this direct, we know that we have problems with some states trying to notify people sending documents directly. This is a problem that we have, but I don't know if documents like birth certificates or something. But the Ministry of Foreign Affairs is not really involved more. They are trying to not be too much involved with this document since the apostille convention, because now we have to go to the notary and have the apostille. So I do not know. We have less and less requests going through reciprocity, which was the way we used to when we did not have any agreement or bilateral agreement. So we just send the documents to the Ministry of Foreign Affairs, and they send it to the other Ministry of Foreign Affairs in another state. But this is getting less and less common now, because we have a lot of treaties, international treaties, and we do not use it so much. But yes, I think it will be accepted if it goes through the Ministry of Foreign Affairs.
Professor Nord, I think we do not have any more questions from the session. Would we have any other issue, or could we re-adjourn for next week?
I don't know if anyone still has a question or not.
I would just add something, if you allow me, Mr. Secretary General. Thank you a lot for this invitation. And as I said before, Switzerland is very happy about this seminar with the Brazilian colleagues. Thank you.
Thank you, Ms. Montini. It's really our pleasure. We are the ones to be thankful here. And again, I would just like to thank Professor Gustavo Cerqueira, who allowed us all to be here today discussing this very important issue. Thank again Gabriela Jardim from IDP, who is organizing this logistics of the seminar. Thank you, Professor Nord, again for being so available and so clear. Thank you all representatives. Thank you, Ms. Lalisa. Next week we'll be here again discussing with Professor Nadia Araújo the very, very important issues of recognition of international acts and documents. Isn't that it, Professor Nord?
Yes, we're going to try to study the other facets of the normative instruments of the Iccs, and just to have a general overview of the whole system.
Hope to see you all next week. Thank you very much again. Bye-bye.
Thank you very much. Thanks a lot.
Thank you very much.
Bye.
Have a good
Sweet.
day.
Thank you.
Bye.